Thank you very much, Minister Kaljurand. Please take a seat. Thank you. And thank you very much. I think we've just got time to sneak a few questions. If I could just take you in order. Vice President Ansip, there's so much in the remarks we've just heard, so much content, and I'm sure that we can pick up a lot of the themes in the panel session that follows immediately on from this. But if I just had to pick up one theme from your remarks, it would be about geo-blocking, which here yesterday was a topic of great conversation, particularly among the younger members of the group. They absolutely hate it. So what are you going to do in the digital single market?
Once on press conference, I said that I hate geo-blocking. Of course, some people, they were disappointed, but I'm not the only guy who has some problems with unjustified geo-blocking. There are 35% of Europeans who spend at least 10 days during the year in another EU member state. And many of those people traveling in some other EU member states, they would like to get access to their legally bought content in their home countries, but because of copyright restrictions, they cannot. At the same time, we know that 20% of internet users are using VPN to get access to digital content. And even 68% of film viewers in the European Union, they said that they are using free download. So we don't have to push our people to steal. We have to provide legal access to our people to their legally bought digital content, and that's why we launched last December our portability proposal. Just 2 weeks ago, we launched our geo-blocking proposal. We organized mystery shopping survey, and according to this survey, there were 2% of those people who wanted to buy something from another EU member states who couldn't get access to those websites. 2%, let's say, almost nothing. But even 27% from all those people who got access to those websites, they couldn't register it because they were from wrong country. Their IP address was wrong. And that's why they couldn't register it. Then even 32% of those people who were really lucky ones and who were able to register it, they faced with delivery problems. Well, those are natural problems. We have to find solution also for those problems, and that's why we launched our parcel delivery prices proposal. But even 26% from those people who didn't have even any kind of those delivery problems, they couldn't pay. We have SEPA in the European Union, Single European Payments Area, but 26% of people, they couldn't pay because their credit cards were issued in wrong countries once again. All in all, only 36.6% of all those people who wanted to buy some goods or services from another countries, they were able to do that. And my question is this really about single market we have in the European Union when only every third person is able to conclude their purchases successfully in the European Union? Of course, we have to fix this problem, and that's why we launched our geo-blocking proposal, and it means that sellers, they have to treat all the customers equally. They have to treat those customers coming from other EU member states on equal basis with local customers. In the end of September, we will launch another proposal. This will be our second copyright reform proposal, and with that proposal we would like to make it easier for our people to get cross-border access to digital content. So once again, I hate geo-blocking. I don't like those messages that this video is not available in your country.
Thank you. Thank you very much. Again, I think that there are many aspects of this issue that we can pick up in the next discussions, but just keeping an eye on time and wanting to hear from everyone. Secretary General Jagland, again, there's lots of things that I would like to ask you, particularly about your remarks relating to the need for a light touch and the need to, to really go carefully with regulating the internet. But I wanted to hear more about the study, because this seems to be extremely concerning amongst the 47 member states of the Council of Europe, what you've uncovered, and perhaps you could just tell us a little bit more about that.
Yeah, well, the study is very broad, country-wise. It is a document of, I think, 600-700 pages. So it goes into details on how our member states are doing this. And as I said, there are so many different practices, so many ways of, or so many policies that they apply, and so many ways of taking down content on internet. And what worries me is that, well, some countries are going much further than we would like to see, because it harms freedom of expression. One can use, for instance, fight against terrorism for many things. One can to fight terrorism, but one can also fight political enemies under the cover of fighting terrorism. And so there are so many practices, and I would say also abuse of freedom of expression, which worries us, and that's why we, on the basis of this study, we will start now trying to work out common standards for the member states. And these standards has, of course, to be built on the European Convention on Human Rights and the case law of the Court of Human Rights, which is a very good guide. I would like to say to everybody that whenever you are in doubt, look at the case law of the court from Strasbourg, and it will guide you on what kind of laws and what kind of practices you should have on the European continent. It is, of course, a very complicated thing, all this, because, I mean, there are different cultures in Europe also, different historic backgrounds. Some countries accept one kind of content, other countries it would be not natural to accept it. And the reason also why all this is difficult is that there are so many things which we dislike, the dark sides of the internet. We all agree that this shouldn't appear, shouldn't be there. And but the danger is that one is using this in order to go much further in blocking and filtering than what is, so to say, covered by the standards in the European Convention. So it's an extremely... I mentioned, for instance, the fact that we have found all these horrifying domain names. For instance, the one domain name that existed but was taken down after we actually reacted. One domain name was rapeachild.com. This existed. What do we do with this? It has to do with the whole way of how you can obtain a domain name. We would not, of course, like to block people's right to establish a domain name, because that would really harm the internet and access to information and knowledge. But at the same time, we should find ways of, not letting that kind of things be on the internet. And I would like to say that, as you refer to Malala, that got the Nobel Peace Prize for her struggle for education to everybody, we should understand the importance of internet for getting access to information and knowledge worldwide. And if we are doing something which may harm the open internet, access to internet, but also access possibilities to establish domain names, then you really will harm these basic rights, for instance, education for young people on a global scale. So we have to be very cautious, but we need also to take on things that obviously will reduce or tear down the trust in internet. And the only way to do this is in direct cooperation, interaction with the private companies, because they have always been the driving force behind the internet. We do not want to harm it, and it should be in these private companies' interest that they work with, for instance, people like us that are concerned with human rights, and we have the same interest, namely to safeguard the openness of the internet together. Thank you.
Thank you, and to build trust. Minister Kaljurand, your remarks actually brought up the security and human rights, and these are often pitted as sort of mutually exclusive or in opposition to each other. And as we heard from the Council of Europe study, there's a lot of these practices of taking down and blocking in some ways are done, often from well-intentioned motives. So how do we, I don't want to say get the balance right between security, but are they in opposition? And what's your view on how do we actually get the most out of the internet for human rights while also keeping people safe?
Well, Emily, thank you for the question. Very challenging. I agree absolutely that these two notions, security and freedom, do not exclude each other. Full stop. They do not exclude. But although you don't want to use the word finding right balance, we have to find right balance. Estonia was among the first countries to recognize human rights online equal to human rights offline. Full stop. That's the basic. At the same time, we are a country that has benefited most from ICT development in all spheres. Political, economy, culture, civil society, name one, everywhere. So I think that we can lead by example, showing that a country that respects human rights can benefit the most from ICT and cyber. And as to the right balance, sorry for using this word second time, but I think we need discussions, we need dialogues. Today, we don't have a solution that is 100% acceptable to everybody. There are different thinkings, there are different cultures, there are different histories, as also Secretary General just pointed out. But we have to talk. We have to talk among countries, we have to talk among organizations. And here I'd like to mention, we're talking about the EU and Council of Europe, but for example, OSCE is doing a great job in that field. And we need a dialogue between government, private sector, experts, academia, civil society. And last sentence, and conference like this one is extremely good for providing platform for all stakeholders to participate.
And just one follow-up to that is that the security community do tend to meet separately from the EuroDIG type of community. So on a kind of, let's think about next year in Estonia. How are we going to bring together more, get this dialogue really going and getting the security community in the same room as the EuroDIG community, the human rights community, so that we can all share that dialogue?
Well, maybe you're right. We don't see too many people coming from security services or security field here, but they are included in the discussions that are going on. Being security people from private companies, national security services, they do participate in the dialogues. They are in government, they do participate in UN working groups, they do participate. Yes, maybe they are not always on the stage. They prefer to be behind the stage. But yes, I agree with you that we have to talk to them more openly, more often, and I can't make promises on behalf of the next EuroDIG, but at least we'll try. We'll try our best to have a good dialogue there on security, human rights, human freedoms, and balancing. Third time, finding the right balance.
Finding the right balance. Well, with that, thank you very much. I'd like to thank all three of our speakers this morning. It's been tremendous to have your participation and to have this dialogue with you. So I'd like us all to thank Vice President Ansip, Secretary General Jagland and Foreign Minister Kaljurand. Thank you very much. I would like to thank you very much. Thank you. So, you've all been sitting quietly for the last, well, nearly an hour. Thank you very much, and thank you to our speakers. What I'd like to do now, we have panelists who I can see dotted around the room. Could I just ask you to come and take your seats for the next discussion? But what I'd like to do is to give the audience an opportunity to raise any questions or remarks or reactions to what you've just heard. Really, we have a fantastic panel coming along now who can pick up with great authority a lot of the subject areas that we heard in the last speakers. So, who would like to pose a question, or shall I just crack on with the panel? Anybody? Are you just all thinking? Oh, great. Ian, come forward. There should be a microphone down here. Thank you very much. And I'd encourage, I'd like about 3 or 4 remarks from the audience, if we can, before coming in and introducing our panel and getting their thoughts.
Shall I, Emily?
Yes, please go ahead.
Yeah.
Introduce yourself and then crack on with your question.
I'm Ian Brown. I'm Professor of Information Security and Privacy at Oxford University. I think it was very positive, the discussion you were just having, Emily, with the Minister about trying to get security much more integrated into these multi-stakeholder debates, because as Cathy Brown also said yesterday, those debates really lose out from all the expertise and societal legitimacy they could gain from being integrated into EuroDIG and things like it. I think a way that perhaps the technical community, both the companies and academia could help with that, is to really have a lot more of the developers and the designers come along and really get stuck into the debates, because as we all know, they have a huge impact on human rights and the impact of technologies on people. And all of the people that work on privacy-enhancing technologies, for example, which the European Commission has done a great job in funding for over a decade, many of those technologies could really address some of the legal and social concerns raised at these meetings, but they won't if those people don't come along and explain what they could do, and hopefully get the CEOs and the people at the top of the businesses to start integrating those privacy-enhancing technologies into their widely used browsers and other kinds of software.
Thank you for that, Ian. I have a question for you. How would you do that? How would you get them into the room? Because, look, people, we're all of us in different ways are on this circuit and overrun with requests to go and spend 3 days here or there talking, and it'll be good for us.
Yeah.
What motivation would they have?
Good question. Perhaps try to do co-located meetings. So maybe think in 2 or 3 years' time, could you do EuroDIG at the same time and place as an IETF conference, perhaps?
Thank you very much. Sir?
Hello, Matei Vasile from APTI, Romania. It was said earlier that we need to start talking to security people. Actually, it's the other way around. They need to start talking to us, because usually they are the one avoiding us and disregarding our input. At least that's a lot of our experience when trying to defend digital rights. Thank you.
Does anybody feel like having a crack at that? A remark or not? That seems to have silenced everybody. So it's not that we won't speak to them, it's that they won't speak to us. I often find that people in conflict situations have the same sort of response. But I think that you just have to keep trying, huh? You've got to just keep trying the dialogue. I don't know. I don't have the answer. Anyway, welcome to our panel. Very nice to have you all here today. I think what I'll do is I'll just run through and introduce the panel to you, and then just perhaps ask you to give some initial reactions to the speeches we've just heard and the subject matter. There's an awful lot to get stuck into. I'll start with you. This is, ladies and gentlemen, Kaja Kallas, who's a member of the European Parliament and was also co-rapporteur of the report towards a digital single market. So I imagine that you're fairly well embedded with the ideas about geo-blocking and all of the other themes that come through on the digital single market. But one of the things that we were talking about yesterday is about why it is that Europe doesn't seem to have produced the entrepreneurs that other countries or other regions have produced. And why do you think that is? Is it because is it something in our DNA, or is it something about the regulatory environment?
First of all, I don't think it's in our DNA, but I also at the same time think that it is about the environment and also mentality that we have in Europe. And what I've very often said, that the mentality is not very risk-prone in Europe. And if you just can't take risks, if you have to be 100% successful, then you also have zero gain if you have zero risk. And if we treat failure as failure in Europe, then also all the people who try, of course you don't succeed the first time. So it's maybe easier to fail elsewhere. But I just wanted to come back to the comment that was made about the security people. I actually agree that very often we have the discussions only amongst the policymakers and the companies and the consumers. But when it comes to human rights, when it comes to really tackling hate speech, all the problems that we have and the discussions there, then we should have the security people on those panels, because then you really have the debate. Because on one side, of course, there are arguments that we have to survey everything and try to get the bad guys in the internet, but at the same time there are so many risks related to that if we start to do that. And at the same time also we have to understand that people's behaviors have changed very much. So although when we have the discussions about the security, then we have calls like you shouldn't have encrypted communication, and it should be open to police to look at. Whereas if we would have the same conversations in the offline world, that please, all the people, keep your doors open because police wants to come and see what you do there, then we would say it's absurd. But on the internet discussions, it's on the table. The same, of course, we have to look at the other side, that people also do things that they wouldn't do in the offline world, like post their pictures on their front doors or windows about their children, or post a sign on their door that, by the way, I'm not home, I'm on holidays in Spain. So they wouldn't do this in offline, but they do this online. So I have to keep this in mind, that the trust is very important, but also how to find the balance.
Okay. anybody who wants to ask a question, we've just heard a lot of speeches, so my plan is, if anybody wants to ask a question of any of the panelists or contribute to this conversation, please do so. Please come up to the microphone, please raise your hand, and we'll carry, don't worry, we'll carry on talking, but if you would like to join in this conversation, you're very, very welcome to. Okay, I will move to the next panelist. Stefan. You're going to have to help me with your surname. I'm so sorry. Kravchik. Stefan Kravchik, who is the Associate General Counsel and Head of Government Relations International at eBay. And I think this is a very nice link with the remarks that you were just making. Here you are in Europe as a European, working for a global company. Do you sense a difference of approach in terms of risk-taking, and how do we get an entrepreneurial spirit in Europe while protecting human rights? And the role of companies in takedown, I know that there's an awful lot of work that eBay does in that regard, with regard to counterfeit goods, for example. So, you have responsibilities, you take those responsibilities. How do you do so in a way that doesn't end up eroding human rights?
Thank you for that question. It's probably one of the most difficult questions we've been struggling with that for a good decade, if not more, probably 15 years by now. And what we see is that the more the outside world thinks that something is really easy for an internet tech company to do, the more they will actually burden that company with doing it. And that can range from tax police saying, listen, could you please give me the sales figures of all your users in the Milan area? We just want to have a look at them and see maybe if we can pick out a few that are selling more than a private person should be selling. Or it could be something that we've faced in Germany, even by the German constitutional or the Bundesgerichtshof. They said, well, if you have a producer of children's chairs, Stocker, the Trip Trap, and knowing that these are of very good quality and people can sell second-hand chairs when their children go out of them, there are also a few cheeky producers who make imitations of them and they put them online. eBay, could you please check every single listing of a children's chair that may look like the Stocker children's chair, and if you think that it is infringing their design rights, please take it down. And the list goes on and on and on, which for a company like us is extremely burdensome. And now
and do you feel that people are just foisting that on you?
Absolutely.
Just in the absence of anything else, or because they know you can technically do it?
Absolutely. They think it's easy, and so the burden is on us. But we come back to the innovation piece here. A big company like eBay has the bandwidth to deal with a couple of those cases. Can you imagine a European startup who wants to engage in the same line of business that gets this burden slapped on it immediately? They will not even begin with their business. They will just drop it, move somewhere else. And Europe is really, if this is allowed to be the general rule, Europe is driving itself into the ground.
And do those sort of those requests, are they solely coming from Europe then?
They're coming everywhere, obviously.
But
it is under the European regulatory system that certain courts in certain member states, and Germany not being the least of them and the smallest, actually come with rulings like this that really put innovation and freedom of speech in danger, because we put a responsibility and a liability on intermediaries that make them that create a situation where they actually feel the need to do this in order to stay out of the line of fire. But it isn't the right balance of duties, and there is no legal check and balances that are in place.
So you're just mentioning intermediary liability, so I'm probably going to come to you next, Christina, if I may, and then I'm going to come back to you, Joe. Dr. Christina Angelopoulos, who's actually, you're based in the University of London, aren't you, at the Advanced Legal Studies? And we've just heard about judgments on intermediary liability and imposing more and more burdens.
Right.
Let's sort of think about this sort of overarching question. Are we actually stifling the economics of the internet by imposing burdens on poor eBay and poor all of the other companies? Or actually do these companies, should they have some sort of duty of care?
I think that's an excellent question. I'm not an economist. I can't really speak to the economic aspects of what will invigorate European economy digitally. What I do think is very important from the legal perspective, however, is to dig into the legal principles and try to figure out exactly what a law-based solution would be. And then once we know exactly what those parameters are, we know what the playing field of policy can be. And at that point, we can start considering what we can do with regard to the economic aspects and how we can take an approach that will be best suited to invigorating the European economy. So I would start with trying to parse out the legal issues. And I think this is a very difficult aspect, because I think that what has happened a lot is that information society has thrown a lot of our settled legal conventions into disarray, so that we're being forced to retract to very basic principles of law, such as human rights and fundamental rights, and try to recreate sort of ideas of how we go about settling what traditionally has been situated in much more mundane areas of law, in tort law, in criminal law, and so forth. So what we're seeing is sort of like a reopening of the normative, of the discussion, the normative deliberation on the basic underlying values of our legal systems, and trying to figure out how we can approach that. I think one starting point would be to try to calm down a bit and see exactly how we used to approach these things in the past, and how we can reinterpret existing rules and apply them to the new internet era.
Thank you. So we should all just try and keep calm. I think this is quite a good piece of advice with the internet, because we're always told, oh, the internet changes everything. And of course, the technology is incredibly exciting and disruptive. But there are lessons that we can learn, right, from the last couple of thousand years of, if we're sitting here in Europe, you've been struggling with these issues for a whole 15 years, and actually you see similar sort of dialogue and struggles going on in ancient Greece about similar issues, and how you get the balance right between, the strong arm of the law and people's freedoms. Perhaps I can come to you, Joe McNamee, is the Executive Director of EuroDIG, which is a European human rights organisation. How do we get the answer, but how do we, mainly, I know that you'll be very strong on human rights. What I'd like you to do is to try to put yourself in the shoes of an entrepreneur, maybe a startup in this region, and think, well, how do you make sure that they can thrive? And because we all need these businesses to thrive without necessarily squishing human rights.
Absolutely, and I think for the most part there isn't a contradiction. I'd like to come back on the liability issue, because I think that's quite central. First of all, in that context, I have to praise the Council of Europe for the study. It was a really brave decision to look in detail at what the member states were doing, look in detail at the law, look in detail at the practices. I'm amazed that it was done, and I'm amazed that it was done so well.
And it's hard-hitting, and it names names,
yes,
and it's,
yes. It says a lot of things we've been saying for years, and which is nice to get independent verification. One of the things that the Secretary General said in the previous session was, with regard to illegal activity, we need a clear and united stand. And that means dealing with the problems in a comprehensive way. There's an episode of The Simpsons where Homer Simpson gets elected on the slogan, "Why can't somebody else do it?" And for most of the history of internet regulation, that's how regulation is seen. And it's the approach of politicians is sometimes it's an almost beautiful ideological vision that they can give eBay a problem. It could be a liability problem or it could be a public relations problem. And while eBay is solving that problem, eBay is going to accidentally solve a public policy problem. And it's going to accidentally solve this problem in a proportionate, necessary, predictable way, magically.
Magically.
In a changing internet, it's going to continue fixing it as the internet changes. It's going to fix it durably while not creating any counterproductive side effects for the public policy objective.
This is sounding great.
But it is blind ideology, I'm sorry, but as wonderful as eBay is, and even if that were to be the case for eBay, it mightn't be the case for the companies that are startups that don't have the economies of scale to do what Google...
and it's not eBay's actual job, is it?
Well, that's what I was saying. We're expecting them to accidentally solve public policy problems while solving the liability problems that we're giving them. It is not serious policy making. And as the Secretary General said, clear, united approach to dealing with problems.
Thank you. And that leads nicely to our speaker from the Council of Europe, who I think is not Ambassador van Eekhout.
And I'm not with the Council of Europe, so I'm the disruptor. I'm sorry.
Sorry. I'm so sorry. I was wondering where you were. Apologies, ladies and gentlemen, and especially to you, Ambassador. I saw the panel coming up. This is embarrassing. I'm terribly sorry. Well, perhaps I can come to you, but excuse me.
I mean, Mr. Ambassador.
Thank you. You started your remarks, but this is just not going to continue. So, yes, I'd like to come to you later. Ambassador, I'm so glad that you've joined us, and I was wondering where you were.
I was listening. Ambassadors usually talk, but I was for a moment an exception and was just listening to a very interesting conversation.
Thank you very much. But of course, as not only the ambassador, the ambassador to the Council of Europe, this is great. Thank you. This very internet solution, solving things by accident. So as well as being Belgian ambassador to the Council of Europe, you're also the thematic coordinator. And so you are the person, the sort of focal point to really speak about this report, which is causing a lot of excitement. It's nice when you have both civil society and others welcoming these sort of reports. It must have been quite, quite a sort of quite a challenge to put this together, and I'd like to know where it's leading. And we heard from Secretary General Jagland that this is going to maybe create some standards, which I'm hearing from different people could be very helpful in championing human rights.
Thank you very much for this question and the reference to the study. I do think that the study is a game changer. It's the first time that actually, as was said before by you, that we have a state of play. How, in the 47 countries on the continent, how is the situation when something needs to be filtered, blocked, or taken down? What regulation where applies? So, actually, it's a very comprehensive study, and the Swiss Institute that did it put a lot of work in it. But it's let's say, the easy part, because your question is the difficult part. So what next? What do we do with this study? Why could it be useful? I think for a company, it must be very useful to see what regulations apply in what countries, because if you're doing business on the internet, you're not doing business on the internet necessarily just to doing business in your own city or country, but with a global reach if possible. And then that is very useful material. So we could think of updating this, transferring this into a database, continually updated. It is not only interesting for businesses, but also for NGOs to see where there are gray zones, where there is nothing. And there comes the role of the Council of Europe, because what is the Council of Europe doing? On the basis of this, it could construct best practices. It could give orientation, recommendations, not hard law, but the recommendations. This is what we see. This works. This is well accepted. We see there's a gray zone here, so please get your act together, do something. What does the Council of Europe also do? It is monitoring. How is this applied? Because it's one thing to have regulation, it's quite another thing to apply. And the third thing that we do is, okay, there are countries and there are zones where these things are not that developed. Well, Council of Europe does capacity building. We organize training seminars, actually together with other international organizations, sometimes with the EU. We're thinking of doing this with the ITU. So this is the three, these are the three fundamental core elements of what we do. It's benchmarking, standard setting, it is monitoring, and it is actually capacity building.
Thank you. Just because you're sitting next to each other and because I'm still actually recovering from the last 5 minutes shock of my mystery panelists, so sorry. Now, could you just, both of you, both Kaya Kallas, MEP, coming from the European Union side and the digital single market, sort of very much orientated towards innovation and a single market. How do you think this study and the Council of Europe's role in the human rights aspect will support each other, and how are you going to work together to achieve that?
I think the study is always very useful, and it is useful in that respect to understand what is there and what needs to be done in different member states.
Were you surprised at some of the practices?
Well, not really, because we know also the practices even in European Union, not even wider, but even in European Union we have differences, and I think what we have the discussions about unified rules and understandings, it is very important. But the question, of course, is always the implementation, and different countries see the rules and their implementation differently, and so we still end up in a position where we don't have a unified approach. Because for one country, because our histories are different as well from where we come from, and therefore the attitudes of people and the policymakers are different. So I'm not really entirely skeptical, but cautious, being optimistic as well, that we can solve these issues. But I think the fundamental question first is to understand that these are the problems, and together actually we can have the best practices, and as internet is global, not European wide even, we should look at these things in a uniform way to have it under control. For example, the same what was brought as an example as child abuse online. So it's not a European thing; it's a global issue, and so if it is regulated in one country, it moves to another. So it has to have a common approach everywhere.
Yeah, and one of the things, perhaps I can, perhaps people from the audience might be able to pick up, is that we also have to think about the competitiveness of Europe as a bloc globally, and that if we actually weigh down our businesses and entrepreneurs with a lot of regulation, we're not going to thrive. There's already a lot of worries about transatlantic data flows. There might even be worries about data flows between the UK and the European Union in a few weeks' time. Who knows with our surveillance laws? Something to look forward to. Anyway, are there any questions from the audience? I'm going to come to you as the first question, but please, there are microphones there and there. You've got an amazingly knowledgeable panel and an incredibly interesting subject. We can talk, but we'd rather hear from you. So please stand up and ask a question. Thank you. Ambassador.
I would still like to make an additional comment about not burdening companies with excessive ruling. Well, exactly. That's why we prefer to have a dialogue. That's why we prefer to have a platform with business. We know that the internet business is a creative, dynamic process. And these two things, I think, can go hand in hand. You can either wait for a wheel going off your car, having an accident, having a reputational accident, or you can engage into a dialogue where you're aware of what potential risks are. And then I'm talking about human rights. Does this put European companies at a disadvantage? Well, let's look at this. The conventions of the Council of Europe are not only conventions that are signed by the 47 European countries. The Cybercrime Convention, as you know, is signed by Japan, is signed by the United States, by Canada. So these are things that are, I mean, globally of interest. If you're doing business in the United States or Canada or wherever, you would like to know how actually crime can be persecuted and what are the rules applying. So it is not something that is an extra burden. It can also be seen as a guarantee to protect your business. Do you really, I mean, another important convention that is globally, the Istanbul Convention about abuse and violence against women. Do you want your company to be associated with a tendency that is careless in this respect? Not at all. And it is a global convention. So that is the Estonian Ministry of Foreign Affairs was talking about upscaling. Well, some of the conventions of the Council of Europe are not just European, they are upscaled at a global level. Because I think they're universally seen as concerns of your clients that are also citizens. And again, instead of waiting for a decision of the European Court of Human Rights, we could have this human rights by design in a dialogue where you tell us what is possible and we tell what we think that your clients think is necessary.
Okay, I have a question from the audience and then I've got several people who are wanting to come in on that. Should we go to the audience and then come back to you?
Thank you. Valentina Pellitzer, Women Platform. Civil society activist. My personal activist obsession. We talk about economic growth, innovation, burdens, and we talk about people-centered. We talk about the user and the citizen. And then we have things like TTIP and public-private partnership twisted and never applying. So maybe it's a big question, but I find this mantra just avoiding the elephant in the room. There is a difference of power. The government that should talk and do things on behalf of the citizens, for the citizen, close the door. The big company shape the conversation for everyone, raising the bar for the small company. And then we say innovation, economic growth, where is the development? Where is it? Should be human rights, the fundamental that we never change? Is corporate responsibility linked to human rights? Or it's just pour parler? Thank you.
Thank you. So who'd like to pick up on that one? Joe and you, Stefan, and I know that Kaya... Okay, go for it, and then you.
unsurprisingly, would tend to agree with that statement. I think there are certain mantras that keep being repeated until they become accepted. One of them is that internet intermediaries can solve all the world's problems. Another one is regulation equals burden. Mm-hmm. That's not true. Regulation allows predictability, allows structure. You know, if you want to remove regulatory burdens on car drivers in Brussels, we can remove the traffic lights, and let's see how happy everyone is with the burden removed.
I think there was an experiment about that in the Netherlands, wasn't it? It worked brilliantly.
So well, we're all doing it now.
Point of information. Okay. So we're not all doing it now. Take your point.
And I just briefly, in terms of Council of Europe conventions, in terms of conventions that can be signed by non-Council of Europe countries, we should remember Convention 108, and rigorous implementation of that around the world would greatly improve predictability.
So for people who aren't up on their numbers, can you tell us what 108 is?
I can't believe anybody does not know what Convention 108 is. Well, it's on data protection.
Okay, thank you. Kaja Kallas, MEP.
Yeah, well, I wanted to come back on this conflict between the companies and the overall or the consumers. So actually, there is no such conflict. I think also with the governments as well as the companies, because everything that is done in internet also for the companies is based on trust. So if the company loses the trust of the citizens, it also loses the business. So we have studies in European Parliament also shown that the consumers have more and more power. They have never had that much power before because of all the feedback systems and everything. So actually, they are also, making the case. And I think this Apple case regarding CIA or their conflict with CIA was a good example. And I think the company gained a lot from this, opposing to these ideas coming from CIA, and it was a good PR campaign for the consumers as well, that they are not going forward with this.
Could I just press that point a little bit, because we do hear a lot that there's a shared interest in trust all around, that everybody's interests are in fact aligned. And of course that's true, of course it is. But at the same time, it's not true as well, isn't it? And it can, that businesses have slightly different drivers. So if Stefan's company were asked to take down something that may or may not be illegal, you're going to err on the side of caution because you're going to protect your own liability. That might not be what you, sitting from the Council of Europe, would recommend to happen, because it might potentially stifle freedom of expression and so on. And so while it's true that trust is important, we also have to be a bit real here about how realistic it is for people to switch between services when you have an increasingly concentrated market for the global platforms. We love them, they're brilliant, but it's not so easy to be on a social network with one person.
Yeah, true. And of course, the issue of porting your content to another platform, I think it's a different issue. But we can't say. We also had a study that people trust the online platforms the most. So this is what they trust actually. Search engines was the first thing they trust. But let's not go into that. But what I wanted to comment also was that the regulations do not necessarily create the burden, but also can be improving the environment. So I also can bring the example from Estonia. So from 2000, we had the law on digital identities and digital signature, and actually it has improved a lot our environment as well, and giving the security for the people that you can have encrypted communication. You can have also what what is fundamental for this trust, that you can understand that who is who on internet, because what the internet or the anonymity in the internet brings is the feeling of impunity, that I can do whatever there. And what's the hate speech also about is that, like, nobody knows that it's me. I would never say such things out loud, but if everybody is properly identified so that everybody understands that, okay, this is the person, would you really say it aloud then? Then I think this is a very fundamental issue, that we should have the digital identities for internet.
So I'm going to go to you, sir, for your...
Yeah, sorry for
not at all.
playing the disruptor, but I think I had been regularly invited, and we have a few things to say, so here I am.
I'm delighted to welcome you.
Patrice Chazan, Digital Europe, and we are supposedly the voice of the digital industry in Europe. And on economics versus privacy, we have a few things to say. One is that, as you heard about security versus privacy, there is no position in our mind between economics and privacy. Economics is not stifling or let alone killing privacy. The economics of the internet is helping everybody express themselves. So I think freedom is the best way to make the most of people. So that's the first point. It's a simplification. There are problems, but as there are problems in the physical world when you let people free. So we empower people, and we also have to make sure they are educated to use the power correctly. And I think that that's a collective work, including with the Commission, the Council of Europe, and all collective society, government and industry together. But the other thing I would like to say is that we are not the only ones spreading chaos. Because the judiciary sometimes spread chaos. For example, I don't think we have mentioned yet the right to be forgotten, but it's really very unfair to give what used to be a prerogative of governments, of the judiciary, to tell what request is receivable, what is not, to a private company. So they did the right thing, but probably they were not expecting to have this role to play. Same thing if you expect ISPs to play a role of policeman, then they need to hide new skills. How much we love the European Court of Justice, for example, when they support us on copyright, because they have a record of telling us you are on the winning side of the argument on copyright. We do hate European Court of Justice sometimes on data protection, because I mean the Shrem case didn't make the data flows between Europe and the US any easier. So as a private citizen, I do think that it's not very healthy to have this confusion between the role of government, the role of industry, and the role of civil society. I mean, democracy is based on balance of powers, and you don't need to have this sort of legal arms race building up, and then have to rely on the judiciary to tell the future, our future. One thing is that they lack the speed, and the other thing is that they lack consistency, precisely because it takes years to get another decision. It's another judge, and you have absolutely no certainty, which is essential to business. Thank you.
Thank you very much, and thank you for raising the role of the judiciary. I think it really highlights how changing this environment is, and that sort of, perhaps part of the downside of everyone being responsible for solving the internet problems is that everyone has a go, and and it sometimes does create confusion, as you mentioned. I've got a question from the audience, and please do come forward with any other questions. And I know that other panelists are eager to jump in as well. So.
So I'm Jeff Ausloos from the University of Leuven. I have two small comments. One to the gentleman from eBay, which made a seemingly very altruistic claim that he's care about other small startups, not overly burdening them with regulatory burdens and access requests, for example, by the government. Of course, eBay and Google and Facebook, for that matter, are targeted because they are so big. So there's not much of an interest for law enforcement agencies, for example, to target these smaller entities with such requests. And with great power comes great responsibility and so on. A second comment relates to the fetishization. Whoa, that's a tough word. Fetishization of innovation, right? I'd rather have 1 or 2 privacy-friendly fitness tracking apps than 20 that might share my data with hundreds of different parties across the world that might not even exist anymore.
Or be hackable for that
matter. Yes, indeed. So instead of trying to copying Silicon Valley successes, why not in Europe focus on building technology, sustainable technology with fundamental rights and human rights from the ground up?
Well, wasn't it interesting? I don't know if you were in the Internet of Things session yesterday and saw the presentation from Ross Lajeunesse of Google, but one of the things that struck me was that the brains behind the textile threads seem to be European person? Yeah.
It is said that if you want finance, go to US. If you want engineers, then it's Europe. So the engineers come from Europe. And I also agree that we should focus on our strengths, what we have in Europe, and build on the strengths rather than try to overcome our weaknesses, which will still remain our weaknesses. And this is definitely the approach. And regarding the privacy, I think we have a different approach with the US in general, and how we see privacy as human right here, and all that is relating to internet and communication on internet is the same. So I think people are becoming more aware of these topics as well, and then it's also a business case for companies.
Christina, and then.
Yes, I just had a comment. I wanted to go back to what we were discussing before about the existence of a clash between intermediaries on the one hand and users on the other side.
Okay, do you have a response to the question from the audience at all?
Yes, because I think that it fits in with that point very well. I think that essentially part of the problem that we're facing over here is that we're trying to address the issues in very broad strokes. And what I would argue in favor would be sort of like to delve into the nitty-gritty and try to pass down, take each individual case as it comes and try to pass down as it comes. I think with regard to the question of clashes, that brings us to the question of balances. The rights that clash are not always the rights of the intermediaries or the interests of the intermediaries versus the interests of the users. Sometimes we have individual rights of users that clash with each other. In those cases, I think the secret that comes with the answer that the courts have been giving, which is fair balance. And in that case, we have to, that's why I was delighted to also hear from the Council of Europe that the next move forward would be a benchmarking exercise and standard setting. And I think these are all considerations that should be taken into consideration when we try to figure out exactly what a fair balance would be in the context of that benchmarking exercise. So one of the things that I think should be taken into account is, for example, the size of a company. I don't think we should hold big companies to the same standard that we hold small companies. And I think that is one of the aspects, one of the many aspects that we ought to start addressing individually and trying to find a way to fit them into the discussion.
Thank you. Please go ahead and then
Thank you. Just to echo what you just said about privacy, and maybe I will try to answer part of the question. Privacy is also changing, or maybe should be changing as well. I mean, because we are human beings, and privacy is something for us, by us and for us. And I would like to quote Professor Floridi from Oxford Internet Institute, and he says, in other words, what you said, that privacy is like our lungs in Europe, and privacy is like underwear in the US. So you can get rid of underwear, change everywhere, you cannot change your lungs. But he hastens to say that if it's not lungs but kidneys, why are we able to donate our kidneys in Europe, and why are we not authorized to donate our data? So maybe that's a question for policymakers. The point is that it's always changing, and privacy as well as the rest. I don't mean that it shouldn't be a fundamental right any longer, the protection of privacy. And to answer the question, we heard it's all about scaling up, the secret for businesses to grow. And I think one piece is missing is regulation. I think certainly there is better access, easier access to capital in the US, but also they have a huge market, and we don't have a single market. I mean, we have heard people say how much they struggle. I mean, the people in charge of building this digital single market, but it's a pity that in the 21st century, we are still trying to build the market, and we are not there yet. I mean, the digital single market strategy is brilliant, it's a visionary, but we are not there yet. So it's not only the judiciary, it's the whole balance of powers that shouldn't be falling on the shoulders of business, because it has been said before, business is not all the time supposed to fix what other people elected to fix it are not able to fix. Thank you.
I think I'm going to come to you, Stefan, for a reaction as the business person on this panel. And I know that I have everybody else waiting. So, and please, we've got 15 minutes left in this session. So this is a moment now to pose your questions and have the panel react to it. Thank you very much.
Yeah, I first want to thank the gentleman, I think from Leuven in the audience, for paying a big compliment to eBay as an altruistic company, which we absolutely are. And we care about the small people, and we care a lot about the small and medium-sized businesses that sell on eBay and make a great living on eBay. To come back, what I basically heard there is if you're big, then you should be subject to a certain set of rules. If you're small, you don't really have to. To me, that sends a message like, you'd better stay small, because as soon as you grow big, man, it's going to be a very scary world out there. I don't think that is what we have in mind. And what I'm saying is, if you create an environment in which any company operating on internet is subject to duties of care and notices and stay down, you force all of them, big or small, to implement general monitoring and filtering systems to stay clean. And
Stefan,
you put the role as police officer on their back.
But I think we have...
Excuse me. I really have to intervene. Big companies know that with power comes responsibility. That's actually what the dialogue is about. Nobody is hitting on big companies because they're big. What is the situation? When you start from a small company and you become important, you first provide a private service, but at some point you become so important that it becomes a public service. And that's when, indeed, responsible behavior applies. And what are we talking about regulations? Well, your customers expect to be treated in the same way, in an intuitive trust that you don't want to lose, and that actually government needs to be sure that it is upheld. This process should be as less cumbersome as possible, because it should certainly not be something that prevents or that becomes a burden on innovation. But on the other hand, the train left the station in the sense that we all expect companies to be trustworthy and behaving responsible. I'm referring to the UN Compact. I'm referring to the European Union's Code of Conduct. This is just the expression of an expectation of responsible behavior. And indeed, it has costs, but it also has benefits, namely the trusts of your clients.
Okay, quick reaction.
I think this warrants a reaction, because I don't want myself to be misunderstood as saying that big companies don't want to have responsibilities. I'm saying that the kinds of liabilities that are put upon us entail general monitoring and filtering obligations that are at odds with very basic human rights. And that, as our kind panel chair said, it actually puts you in a position to rather be on the safe side and get rid of everything, and thus kill the business of small people and private people just to be safe and not to be liable. And that's where the problem lies. We take our responsibilities, and everybody knows that eBay does. So I think that we should put the things in the right perspective here.
Thank you. I'm going to take this question from the audience, and then I know you've been waiting for ages, Joe, so please.
Hi, Ansgar Kuhne, University of Nottingham. 2 points, actually. One is, while I wouldn't deny that there definitely are governments that like to sort of shirk responsibility and put it someone else.
Would you mind speaking up and speaking just
Right.
a slight bit slower so that we can take in what you're saying?
So Ansgar Kuhne, University of Nottingham. So on the one hand, I wouldn't deny that there are governments that like the idea of putting burdens on companies so that they don't have to do it themselves. But isn't it also true that from the perspective of regulators, it is actually difficult to think that they can get access to the kind of information they would need to have that's in the databases of the companies if they wanted to do the kind of scanning through the database to find the problem cases. The company, it is true the company has the database, they have the access, and at least as an academic, we know that it's been very difficult to try to do research projects that require some kind of access. APIs keep changing, those kinds of things. That's one element. The other thing I wanted to raise is the collapse of Safe Harbor Agreement, I would say, is not the fault of the courts. It's the fault of the security agencies in the US that abused their powers and that way violated Safe Harbor.
Thank you very much. So we've got 2 elements to that. We've got a safe harbour element, which I think we haven't covered in much detail, so that would probably be a good last 10 minutes thrash out there, but also sort of access to information and the difficulty, particularly for researchers, in getting that with changing APIs and so on. Joe, can I come to you first on that? And then I think I'll probably, in the last minute, sweep around the panel.
The issue of big companies is a significant one. The internet has been an amazing tool in creating new public spaces. And some companies have been exceptionally good in helping to broaden that public space. But they govern that public space. And therefore, in line with what you said, you expect a certain degree of predictability from them. And I'm involved in a project called onlinecensorship.org, where you can learn about a lot of the abuses that are happening with regard to content being censored.
I'm glad you mentioned content moderation, because this is a very important and big topic for us to deal with in a minute.
That's one of the problems that we have with the hate speech agreement that was reached last week, was that the agreement is that what is illegal will become part of the terms of service, and what is reviewed is the terms of service and not the law. And the text even includes a provision saying that internet companies taking the leading role in dealing with this content. I missed the democratic shift in our society where issues of that nature were being given to private companies to take a leading role.
Well, isn't there an estimated 100,000 workers involved in content moderation according to one article, across the big internet platforms? And this is something that I think people often don't realise, is that this isn't done by an algorithm, it's done by actual people.
Yes. I recommend the documentary Facebookistan, which gives an interesting insight into Facebook's content moderation. I want to say something briefly.
Very briefly, because I want to come to everyone.
About privacy in the EU versus US. Our governments might have different approaches, our legal systems might have different approaches, but every opinion poll and every piece of analysis I've seen suggests that Europeans' worries and preoccupations are very similar to those in the United States. And there was a recent study that showed a vast proportion of people in the US avoiding using online services for reasons of security and privacy. And unfortunately, US businesses is burdened by not having clearer regulation in the area of privacy. Finally, on the one point of shouldn't we be able to give the data? Well, we don't, in the era of big data, we don't know what data is going to be built out of our data. If you've got the Uber app, you will have given Uber access to your battery meter.
Quite right too.
You have no idea why. They have done some big data analysis and have discovered that if your battery is low, you're more likely to pay surge pricing. You didn't know that when you gave them the data. They promised they won't abuse this, of course. Yeah. I believe them.
Thank you. Well, some very quick remarks. I know that we could continue this conversation, and I'd like to hear more from all of you, but we're unfortunately under a time constraint. One sentence.
One on Idris' remark. That's why consent is instrumental in the GDPR. That's the answer. To the question about access to data, regulators have an access which is not the access of other people, and this is rightly so. I mean, Argel, the regulator of betting in France, has free access in case of problem to it's called an e-safe, an electronic safe, and all data are registered there because the beauty of digital technology is that you can trace everything. I mean, but you cannot access everything because there is difference between the layman and the policymaker. And that's.
I think I'm going to have.
And that's about it. Safe harbor I've already mentioned under the other name, Privacy Shield. And I don't blame the judiciary or I don't blame the US. I'm just a layman. I cannot take sides. But again, solution will come from collective putting our head together.
Thank you, Christina.
Right, yes, so perhaps one last word on the concept of a duty of care. I think that if a duty of care is going to be introduced for intermediaries, then we should be, the first question that we should ask is which duty of care? So for example, I would definitely agree with Stefan that duties, that notice and stay down cannot be imposed on intermediaries because it does involve general monitoring. Other duties, however, perhaps may be considered, depending on various factors, including the size of the business and so forth. Should businesses be obliged to share their data with government? Again, my question would be, under which circumstances, for which reasons are governments needing it? That's what we should consider in answering that question, not simply a blanket permission to have intermediaries monitor the information of their users. Thank you.
Thank you. Stefan.
Yes, I think everybody should act responsibly, and that should be done irrespective of whether there is liability or not.
Yes, I would just like to comment on the question that was before on the safe harbor. I think, well, when it comes to the consumers, then more people have the same views about privacy in US. But we had a meeting with US congressmen on this issue, and then you could see that there's a fundamental difference on our ideas about this. So there the security aspect that the security officials should have access to all.
And I think it's also fair, but it's not just the US governments who want that access, is it? Speaking from someone from the UK, but there's also moves right across the European Union for governments to increase that access. And even the European Court of Human Rights is saying it's part of life now to have that access, and that we need to think about oversight rather than...
But this is exactly what I said in the beginning, that this is a different approach on the offline and online. So whereas online it is more likely that everybody, or you could explain to the people, and people would say that, some people would say that, okay, if you catch the terrorists, then let's open all the doors. But then why not then open all the doors also, like literally?
Thank you.
I think we shouldn't have that difference between online and offline.
Thank you. Ambassador.
I completely agree with the former speaker here, the last sentence. There should not be a difference between human rights offline and online. What is legal online, offline and online. But my conclusion of this debate is a very positive one. Indeed, I think there is an interest to have a dialogue with business on the role of intermediaries. Whether they're doing government job or not, what is responsible, what is not responsible, and what are best practices and what could be the orientation. Council of Europe is working on this. So I'm looking forward meeting you and others just to exchange ideas on what is best practice, what should be part of it.
Thank you very much, and thanks for ending on that positive note. We're out of time, ladies and gentlemen. It's now time for coffee. I think after last night's celebrations, we're all grateful for that. So I think we'll reconvene at 11:30. Wolf, did you want to say anything? I'd like to really thank our panelists for an excellent discussion and for their expertise, sharing their expertise. Thank you.